undergoes parliamentary approval. But the problem here is that the CASs are, for all purposes, assistant cabinet secretaries reporting directly to the ACS. The PS is relegated to the position where he reports to the CAS and the CS. Doubt is completely removed by their job description in Gazette Notice number 12432 of 12 October 2022 and duties specified therein, and the fact the CAS will be in a higher job group, CSG3, than the PS. The Gazette Notice gave particulars of the office as follows: duties and responsibility. A Chief Administrative Secretary will be responsible to the Cabinet Secretary in the performance of his or her duties. Specific duties questions touching on the portfolio assigned to the office. B. Providing liaison with the National Assembly and Senate. Providing liaison with county governments on matters of concurrent mandate. Providing interministerial sectoral coordination. Representing the Cabinet Secretary at any meeting as instructed by the Cabinet Secretary. And D. Executing any other duties and responsibilities specifically assigned to the office by the Cabinet Secretary in furtherance of the interest of the ministry. Terms of service. A Chief Administrative Secretary will serve on contract as determined by the appointing authority. B. This position is graded at CSG3 in the public service. The remuneration and benefits commensurate to this level will be applicable, unquote. We also find that whereas His Excellency the President can establish a state office within the ranks of the public service, it requires approval by the National Assembly. Such approval may be achieved by enactment of a statute which provides for the same and further provide an appropriate framework for a cap on the numbers of CASs if necessary. In the end, we are not satisfied that the newly created office of CAS meets constitutional thresholds. Having reached the above conclusion, we are nevertheless still minded to address the issue of numbers. We note that the initial approved complement rose from 23 CASs to 50. By virtue of their salary and hierarchy, we agree with the fourth petitioner that the creation of the offices would come at a substantial cost to the public. The respondents urged us to find that the office is separate from numbers, and that once the office was legally in place, it was beyond the court to look into the numbers or the accompanying wage bill, and that the task fell to other bodies such as Parliament, Controller of Budget, or the Salaries and Remuneration Commission. We have addressed that issue in a separate part of this judgment. The respondents and interested parties urged us to find that once the office of CAS was established, the complement, all number of officers, was at the discretion of either the PSC or His Excellency the President. Our attention was drawn to the case of the Judicial Service Commission, which recently advertised for 6 posts of Court of Appeal judges but hired 7. We distinguish the above example from the present scenario on the basis that at the material time there was a vacancy and JSC did not overshoot the ceiling of 30 judges set for the Court of Appeal. The respondents and interested parties also relied on the decision in Sheria Mutahi na Shadrach Waboi Supra. The petitioner in that case challenged the employment of 350 persons by the PSC for the position of accountant 2 in the National Treasury, but when the advertised vacancies were only 250, the petition was dismissed. But that decision can be distinguished for 2 reasons. Firstly, in the instant consolidated petition, the office created is a high public office with substantial salaries and perks. And secondly, the Shalia Mutani case was dealing with hiring of lower cadre of public officers, being accountants too. As we pointed out earlier, in interpreting the Constitution, this court is bound to adopt a purposive approach which seeks to give effect to the true purpose of legislation, unquote, and may examine, and I quote, material that bears upon the background against which the legislation was created. See Gatirao Peter Munya versus Dixon Mwendagideji. Kenya had for many years a cabinet consisting of ministers and assistant ministers whose composition or numbers was largely at the discretion of the president. The public clamor for control of the size of the executive was reflected in the draft Constitution of Kenya 2005 by the Constitution of Kenya Review Commission. In the proposed Constitution of Kenya 2005, adopted at the Bomas Constitutional Conference on the 15th of March 2004, it was provided as follows. The President, in accordance with this Constitution, shall appoint and may dismiss A, the Cabinet consisting of 1. The Prime Minister, 2. The 2 Deputy Prime Ministers nominated by the Prime Minister, 3. Not less than 15 and not more than 20 ministers nominated by the Prime Minister, and then B, not less than 15 and not more than 20 deputy ministers nominated by the Prime Minister. The number of assistant ministers in the proposed Constitution thus matched that of the ministers. Murima J in the Okia case had also the following to say of that subject, and I shall not read it. The final report of the Committee of Experts, dated the 11th of October 2010, notes that Kenyans wanted, and I quote, that there be a clear distinction between offices of state and offices of government, unquote. Following public debates, the position of the assistant minister was abolished altogether and did not make it to the Constitution of Kenya 2010. It is thus not surprising that the size of the cabinet secretaries is now capped at 22. Article 152 of the Constitution provides that the cabinet shall comprise of A, the President, B, the Deputy President, C, the Attorney General, and D, not fewer than 14 and not more than 22 cabinet secretaries. It is therefore our considered view that the creation of a similar office to the assistant minister, now in name of CASs, cannot be created in the manner the first respondent and the fifth respondent proceeded. Based on the reasoning set out above, we do not think that it was the intention of the framers of the Constitution to have 50 CASs deputizing 22 cabinet secretaries. Furthermore, public participation on the office of CAS was founded on a complement of 23 CASs. Doubt is erased by the following other facts. In the letter of 11th October 2022 by Dr. Joseph Kenywa, Head of Public Service, to the PSC, the Head of State requested the PSC to declare 23 vacancies for CASs. We note, however, that the special issue of Kenya Gazette Notice number 12432, dated 12th of October 2022, and the media advertisement the following day calling for applications from suitable candidates did not set the number of vacancies. Furthermore, the stay in the Court of Appeal preserved the original office created on 24th January 2018. Once that office was abolished on 21st September 2022, the newly created office and complement of 23 office holders could no longer benefit from that stay. Accordingly, the newly created office and fresh complement of 50 had to comply with the Constitution and the criteria set out earlier in Okia's case in order to be lawfully established. They did not comply. For the avoidance of doubt, the entire complement of 50 CASs is therefore unconstitutional. I'll now ask my learned sister, Lady Justice Ongudi, to deal with the next issue.
So the next issue is on the financial implications of the creation of this office and whether the same is a waste of public funds contrary to Article 10 of the Constitution. We have already considered the submissions of the first and fourth petitioners on this issue as set out above, as well as the responses by the second and fourth respondents and the first interested party. We take note of the first petitioner's argument that the advice given by the fourth respondent to the fifth respondent in respect of the remuneration and benefits for persons appointed to the office of CAS was inaccurate and misleading. This was due to lack of information as to how many positions would be created. On the other hand, the fourth petitioner argued that the appointment of CAS is a waste of public funds and resources in the face of the high unemployment levels and economic recession facing Kenyans, that the payment of such salaries ran counter to the provisions of Article 10 of the Constitution with specific regard to public funds, resources, good governance, transparency, accountability, and sustainable development. The first petitioner argued that the fourth respondent did not give advice on the financial implications in creating the office with a complement of 50. The fourth respondent therefore failed to exercise its exclusive constitutional mandate under Article 230 4A. Further, that the fourth respondent, in its letter dated 14th March 2023, had advised for a higher gross monthly salary to that of the PS with no justification, as is clear from the Kenya Gazette Notice number 8792 of 2022. The second respondent submitted that the legislature has the power over public finance and the independent offices of the control of budget and the Auditor General to report to it. These are the offices that should determine the issue of wasteful spending. The fourth respondent submitted that the advice by the fourth respondent on remuneration and benefits for the CS was issued within their constitutional mandate under Article 230, Subarticle 4B of the Constitution and Section 11 of the SRC Act and not the SRC Regulations 2013. The advice was thus based on an objective and fair process which took into account the principles outlined in Article 230, Subarticle 5 of the Constitution and the job descriptions by the fifth respondent. The first interested party submitted that under Article 228, 4 and 5 of the Constitution, it was not responsible for paying remuneration and benefits to the CSS or any other state or public officers following their mandates under Article 228 of the Constitution. We also note that the initial CAS office, as established in 2018, was graded under Job Group U, and the appointed persons were to enter at the midpoint of the salary scale. After this office was abolished and a new one established on 11th of October 2022, the position was graded under Job Group CSG3 in the public service. The gross salary is above 700,000 shillings plus other emoluments as seen from the letter from the fourth respondent. The second respondent, with reference to the 27 additional CSS, made known that their financial provision was given the green light by the National Treasury, which indicated that there was sufficient funds to cater for the additional numbers. we referred to Article 230, Sub-Article 4 of the Constitution, which provides for the powers and functions of the SRC. Further to the above, Rima J in the Okia case found that failure to involve the fourth respondent in the financial matters of the CS office was a serious omission, rendering the establishment of the said office unconstitutional. It is therefore clear to us that the fifth respondent should have consulted the SRC in order for it to ascertain the resultant financial implications. A related issue arising within the context of the various financial implications is the question of whether this court can make a decision on budgetary issues. The court in the case of Wanjiru, Gikonyo and two others, expounding on this issue, opined as follows. By justiciability, it is meant a matter proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision. A court must satisfy itself that the case before it is not caught up by the bar on non-justiciability. The concept is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. It is our considered view that based on the separation of powers doctrine, budgetary concerns fall within the realm of policy and rightly belong to the other relevant arms of government as may be appropriate. We thus decline the invitation to delve any deeper into that arena.
I'll now ask my honored brother, Justice Alem Fisram, to deal with the next issue.
The next issue is, was the President improperly enjoined as a party to the proceedings? The second to the fifth respondent submitted that the first respondent was improperly enjoined the present consolidated petition. The petitioners on their part did not oppose the said prayer, but contended that the misjoinder was not fatal to the consolidated petition. Having considered the submissions of the parties on this issue as set out above, we are guided by Article 143 of the Constitution and the decision of the Supreme Court in, and I will not read the full citation, but more commonly known as the BBI case, where the following paragraphs the court stated as follows, and here I will only quote the relevant paragraphs because we have quite a long quote. Anybody or any party aggrieved by the President's actions or failures can initiate proceedings against the Attorney General, who by virtue of being a legal representative of the government in legal proceedings also represents the President, who is the head of government. The immunity, on the other hand, offers protection that shields the President from civil suits being filed against them in their personal capacity. I will further quote, as such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in the court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein the court may issue appropriate reliefs. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or the person performing the functions of the office of President during their tenure of office in respect of anything done or not done contrary to the Constitution. Pursuant to Article 143 of the Constitution and based on the law as set out above, we find that the first respondent was improperly enjoined to the consolidated petition. We further find that the misjoinder is not fatal to the consolidated petition, but take the opportunity to urge the petitioners and future litigants to avoid this practice in light of the unequivocal pronouncement by the Supreme Court on this issue.
Thank you. I'll now ask the Honorable Lady Justice Hedwig Ngudi to deal with the next issue.
The next issue is whether the consolidated petition was drawn with sufficient precision. In a constitutional suit, a party that alleges violation of his or her rights must plead with reasonable precision the manner in which the rights have been violated. We have a number of authorities on this. And our interpretation of the above provision is that for a constitutional petition to be sustainable, it must satisfy the threshold set out in the authorities we have cited. It therefore follows that the mere citing of constitutional provisions is not enough. The petitioners must, with some reasonable degree of precision, identify the constitutional provisions that are alleged to have been violated and the manner in which the said provisions have been violated from the facts and the evidence of the case. In the circumstances of this case and material placed before this court, we find that the above threshold has been met by the petitioners. And the next issue is on unpleaded issues raised in submissions and supplementary affidavits. The second and fifth respondents and some interested parties opposed the introduction of new issues and new prayers as raised by the third petitioner in its supplementary affidavit dated 5th of May 2023 and the second petitioner's further affidavit dated 2nd of May 2023. The second respondent submitted that new issues were also added in the submissions of the second and third petitioners in paragraphs 39, 54, 56, and 56. The fifth respondent challenged paragraphs 14 to 20, 29 to 31, and 43 to 50 of the third petitioner's supplementary affidavit, and paragraphs 29 and 33 of the second petitioner's further affidavit. The second to 7th, 9th to 18th, 20th, 21st, 23rd to 30th, and 33rd to 51st interested parties also challenged the admissibility of evidence in paragraphs 13 to 17 and 33 of the second petitioner's further affidavit, and paragraphs 18 to 33 and 36 in the supplementary affidavit of the third petitioner. The 19th interested party also challenged the admissibility of the evidence in paragraphs 14 to 20, 29 to 31, 33, 43 to 50, 59 to 61 of the third petitioner's supplementary affidavit. Council emphasized that the record should reflect that they had no opportunity to reply to the new allegations and had not admitted to the contents of the impugned paragraphs. We have referred to the Supreme Court case in Raila, Amolo Odinga, and Stephen Kalonzo versus IEBC and others, and also the Court of Appeal case in IEBC and another versus Stephen Ntinda Mule and 3 others. We are satisfied that the second and third petitioners tried to introduce new issues that were neither pleaded in the original petitions but were found in their further affidavit, supplementary affidavit, submissions, and also found in the amended petition filed out of time, which the court declined to admit. Evidently, each party is at liberty to frame his case in his own way while paying regard to the rules of pleadings, and in the end is ultimately bound by the manner in which the pleadings were drafted. As such, a party cannot be allowed to raise a different or a fresh case without an amendment to the pleading. The court record reflects that the third petitioner's request to extend the time within which to file and serve the amended petition was declined. Taking this into consideration, we have confined our decision to only the matters properly pleaded before this court and as captured in the issues we framed above.
Thank you, Lady Justice Omudi. At this point, what we have been reading are contents of the majority opinion. At this point, I'll ask the Honorable Lady Justice Hedugangudi to read her judgment.
So I have considered in detail the majority decision in this consolidated petition. The factual background the summary of the submissions advanced by the parties as well as the issues for consideration and determination as framed. I'm in agreement with most of the issues in the majority judgment. These issues are the jurisdiction of this court, res judicata, public participation, enjoyment of the president and the control of budgets, and lastly the financial budgetary estimates. I, however, differ with the majority on two issues. Namely, one, whether the office of CAS was constitutionally established, and two, whether the 50 CSs were appointed in accordance with the law. The office of the CAS was first established in Kenya on 24th of January 2018 by the former President Uhuru Kenyatta. He subsequently nominated and appointed the CSs alongside the cabinet secretaries and the permanent secretaries. This decision was soon after challenged in the Okiya Mtata case. And on 20th of April 2021, Justice Mrima rendered his judgment in which he declared the establishment of the CS office unconstitutional. The orders issued are found at paragraph 309 of the said judgment. A perusal of the fifth respondent's CEO Simon Rotich's response in the ELRC petition number E174 as relied upon by the first respondent in the instant consolidated petition indicates that a while later, on 19th of September 2022, the PSC received a letter from the then head of public service, Mr. Kinywa, informing it of the President's proposal on the establishment of the office of the CS in the public service. In brief, the letter set out the history of the office and the justification for its establishment. Equally, the President proposed that the office of the CAS be ranked in the public service within job group CSG3. Further, that one position be established in each ministry, except in the Ministry of Interior and Coordination of National Government, that would have two positions in light of the scope and significance of its portfolio mandate. The letter as well listed the job description of the CAS and relevant qualifications. Based on this, the fifth respondent at its weekly meeting on 21st of September 2022 discussed the proposal and observed that the office had been established in January 2018. However, the process of establishing it had been declared unconstitutional in the Okiya Mtata case for lack of compliance with provisions of the Constitution. Considering the court's decision in the said case, the fifth respondent resolved to abolish the CAS office established on 24th of January 2018, comply with the orders of the judgment in light of the President's request, and conduct public participation. The fifth respondent via a press advert on its website and the local dailies dated 21st of September 2022 invited members of the public to submit their views on the proposed establishment of the said office. And following the call for the public to issue its views on creation of the office, the second petitioner filed the ELRC petition number E174 of 2022 against the fifth respondent for the reason that the advert was illegal for violation of section 27(1) of the PSC Act insofar as it failed to include fundamental details to enable the public make meaningful and informed contributions towards the establishment of the office. Further, that the advert was unconstitutional for violating Article 201(d) of the Constitution as it seeks to establish an office in the public service with duplicity of roles as that of the Principal Secretary. Justice Mbaru, in the said matter, satisfied that the fifth respondent had complied with the orders issued in the Okiya Mtata case and the dictates of the Constitution held as follows in the judgment dated 16th of February while dismissing the petition. Upon being satisfied that the creation of the office of CAS is justified, upon being satisfied that the financial implications of creating such office is indicated, and that the office so created relates to or supports the core functions of the public body requesting for its creation, such satisfaction is sufficient for the first respondent. It is its core function under Section 27(1) of the PSC Act, and in this regard, the internal processes for levels for grading, designation, qualifications and remuneration cannot be faulted. The fifth respondent, in its response dated 11th of October 2022 to the President's proposal, informed of the outcome of the public participation exercise, steps taken to comply with Section 27 of the PSC Act, and after making all these considerations, recommended establishment of the office as proposed. Following this conclusion, the office of the CAS was established via a letter dated 11th of October as communicated by Joseph Kinywa, the then head of public service, to the fifth respondent's chairperson, Mr. Mushiri. With this contextual background in mind, it's my considered view that the petitioners in both petitions, that is the Okiya Omtata case and petition number E174 at the ELRC court, were concerned about the legality of the actions of the former and current presidents in establishment of the office of the CAS in light of the dictates of the Constitution. The High Court, as discussed, found that the claim that the processes towards the establishment of the said office was in contravention of the Constitution, as well as sections 27 and 30 of the Public Service Commission Act, which succeeded. The court as such declared the office of the CAS unconstitutional. That is at paragraph 310B of the judgment. This decision in the end formed the basis of abolition of this office and establishment of the new office, whose creation process was affirmed by the ELRC. Appreciating all these factors, this court will now make a determination on this issue as presented by the petitioners and defended by the respondents and interested parties. It is worthy to note and emphasize that the decision in the Okiya Omtata case, as pronounced by Justice Murima, was stayed by the Court of Appeal. The outcome of the same is a matter that remains unresolved and will inevitably affect the outcome with reference to the office of the CAS in general. On the other hand, the decision in the ELRC petition E174, as determined by Justice Mbaru, was the basis of the fifth respondent's decision to either complete the process of establishing the new office of the CAS or end the same altogether. I say so because from the chronological timelines, it's clear that the fifth respondent did not call for interviews for the CAS position until the ELRC delivered its judgment on the 16th of February 2023. It is further noted that this judgment has not to date been appealed against. Manifestly, the contents of the two decisions arise from courts of concurrent jurisdiction, which legally do not bind this court, as we are of courts of equal status. This was underscored by the Court of Appeal in the case of Bellevue Development Company versus Francis Gikonyo. Be that as it may, this court cannot turn a blind eye to the first and fifth respondents' actions. It is clear that the first and fifth respondents' hearing, owing to the adduced correspondence before this court, in an attempt to comply with the law and the pronouncement of the High Court, established a new office of the CAS based on the orders issued. This compliance was given the green light by the ELRC in its judgment by Justice Mbaru, which cannot be ignored. This act was in line with PSC's mandate under Article 234, A, Roman 1 of the Constitution, which makes known that one of its powers and functions is as follows. The Commission shall, subject to this Constitution and legislation, establish and abolish offices in the public service. My opinion on the preceding point is informed by the Supreme Court observation in the case of Attorney General and 2 others versus D and 17 others. I've cited the portion there. Evidently, the regularization of the office of the CAS as proposed by the President in the letter dated 19th of September 2022 and recommended by the 5th respondent in the letter dated 11th October 2022, being premised on the rule of law, cannot be faulted. The unavoidable conclusion I come to is that the process undertaken to establish the new office of the CS that endorsed 23 posts as seen from the correspondence was lawful. For that reason, the ensuing determination will only speak to the constitutionality of the additional 27 CAS posts. The office of the CAS, as submitted by the parties, was constituted under Article 132 of the Constitution, which essentially spells out the functions of the President. An answer to this question involves interpretation of this sub-article by applying the pertinent principles of constitutional interpretation, which have been dealt with in the majority judgment. But I have referred to the Supreme Court case of Evans, Odhiambo, Kidero and 4 others versus Ferdinand Waititu, and the case of Communications Commission of Kenya and 5 others versus Royal Media Services Limited. And guided by the law and opine above, I find one of the facets of a holistic interpretation to be an interrogation of the past. Fundamentally, the question is what informed the description of the functions of the President before the promulgation of the Constitution 2010. I've referred to the final report of the Constitution of Kenya Review Commission, which states that on the attributes of the President, they envisioned and noted the citizens' contributions. With respect to the office of the President, that 1, the President should not be above the law. A majority asserted their concerns were that it should be possible to prosecute him or her for offences while in the office. In this regard, it was also suggested that the Constitution provide for the President's removal for misconduct. 2, the powers of the President should be curtailed. Kenyans felt that the President should not have the exclusive power to appoint senior government officers. It was suggested that for many of the appointments be vetted by Parliament, and that the President should not have the power to determine the election dates. Now, the Commission on this point concluded as follows at page 199. The Presidency, the head of state, must be more than ceremonial. He or she should have reasonable powers. However, those powers should be limited. Excess powers upset the internal balance within the executive, and the principal function of the Presidency would be to symbolize national unity and promote national integration, security of state, and protection of the Constitution. So it's clear from the historical